the Secretary General. Ladies and gentlemen, dear colleagues and dear friends, welcome to this panel. This is an important opportunity and an intense opportunity. I can't say that it is a nice opportunity per se, because we are talking about a topic that draws and should draw even more attention from the international community as such. So thank you to all for being here, to our distinguished panelists, to the Assistant General, Secretary General Simonovic for having accepted our invitation, for the President of the Council that will say a few words, and whose presence is particularly important to us. And obviously I'm also talking on my capacity as Ambassador of Italy and holding the chair of the EU presidency, but in very close connection with our friends from UDEL, and particularly Dominic, with whom we have organized this panel. I would just say a few introductory words in order to put the issue in the perspective. There is an engagement from many of our governments and many of the member countries of the UN for creating a consensus around the fight against the death penalty. This is particularly important and has gained ground, I would say, till the late 90s, where the idea of a moratorium on death penalty succeeded to make a substantial breakthrough in the attitude also of rejectionist countries. It was possible to table a resolution in 2007, which was the first. We are now working for a fifth resolution on which a moratorium was approved with a very vast majority of members, 154 if I am correct, and what is particularly crucial and important, with a cross-regional representation of countries. So the important issue, like in everything which has a societal relevance in the life of our community, is that it appears clearly as a mandate and clearly as a motivation and as an ideal that gathers momentum in all areas of the world, and it is in no way a value that one region or one set of countries, indeed there is no region which is entirely on the side of the abolition of the death penalty, can give lessons to other parts of the world. So this, I think, is the ideal aspect which is very important in all our conscience. Even those that claim that they are on the side of the fight for death penalty, how long has it been the case? Italy, for instance, is abolitionist, has abolished the death penalty in 1948, which is a generation and a half ago. So other European countries came much later. But still, I mean, there is no reason for us to give lessons to other parts of the world. We have to gather and to understand the roots that make this issue a substantial issue all around the world. And the issue that has a common concept based on the fact that there is no evidence whatsoever, no clear evidence, that keeping the death penalty can be considered a deterrent. There is no scientific evidence of that. Like always in statistics, there are conflicting data that are gathered together, but I mean, there is no body of evidence which is substantial enough to have this opinion to all of us and to gain, I would say, the motivation on this issue. Of the other aspect, and I think it is an important side of the coin, there is the notion which is embedded in the Charter of the UN and is embedded in most of our constitution of the paramount importance of the dignity and the integrity of the individual. The individual who shall never be deprived of the right to life except in condition where this is still the case of execution of a sentence. continue on this fight, we can, I think, obtain two most important results. The first one is, as I said, to gather momentum in other areas of our UN family that are now showing signs of being increasingly reactive to this issue, and we strongly support the ongoing process within the African Union towards the adoption of an additional protocol to the African Charter of Human People's Rights on the abolition of the death penalty. And we commend, I think we have all to commend the African states which are taking the lead in this process. The other issue which I think is very important is that there is no other subject on which a closer cooperation is possible and should be further enhanced between member states, states, and civil society at large. I think that civil society has had a very influential role in the understanding of this matter and in gathering a large body of consensus, even in countries where this is still a pending issue. So I think that when in our deliberation in the Council and the UN at large, we think of how to make even closer the cooperation between the different aspects and the different segments of civil society and our activity as government, this is definitely an issue on which we can work very closely together and obtain more and more results. So I think that this is the issue as it is tabled forward and on which we will have from our panelists insight and certainly elements that will be important for us to take into account. And I would like to conclude by quoting an Italian political scientist who has been very seminal throughout the late century, was also one of my professors at one point, Norberto Bobbio, very much involved with the issue of the UN Italy. And there is a nice, I think, quotation that encapsulates very much the gist of what we are trying to do. The state, wrote Bobbio in the 1970s, has the privilege and the benefit of a monopoly of the use of force, and it must feel all the responsibility for this privilege and benefit. The state cannot equal itself to the individual. The individual acts out of anger, passion, interest, and self-defense. Even the state has a duty to defend itself, but it must respond thoroughly, thoughtfully, and rationally. Being much stronger than the individual, the state does not need to turn off lives in order to defend itself. Thank you very much.
Thank you very much, Maurizio. And let me also welcome you on behalf of the European Union delegation to this evening's event. I wanted to say thank you to the Graduate Institute for hosting us, and also thank you to the colleagues in my own team who've spent a lot of hours putting the event together. Very briefly, the EU's long-standing commitment towards the abolition of the death penalty dates back probably to 1998 in its most official form, which is when we established our first ever set of human rights guidelines in order to set out the means by which we would try to achieve the objective of the global abolition of the death penalty. As the leading international actor to actively pursue this agenda, that of global total abolition of the death penalty, as a policy goal, the EU has already provided over 20 million euros to projects in around 25 different countries. So our commitment is translated through action, as well as, of course, advocacy. The EU is also the first regional body to have adopted rules which prohibit trade in goods which are used for capital punishment, for example. our efforts will go on, but over the last 2 decades, we feel that we have played our part in generating what is overall a clear trend towards abolition of the death penalty. Of course, I would prefer that the panel wouldn't be necessary today, but now, 12 years after the international campaign really began, it remains a fact that thousands of state-endorsed executions take place every year. Thousands every year. So, as the invitation to the event suggests, we are gathered here today with a very simple question, which is, can justice that kills be justified in a modern society? That debate is important, and I thank our panelists in advance for helping to generate it. For only, as Maurizio said, only if we listen carefully to the justifications, to the explanations that come from retentionist states can we try to provide solutions, alternatives, answers to advance the abolitionist cause. This evening I would also like to thank the Assistant Secretary General, Ivan Simonovic, who is here with us today and will speak shortly, the President of the Human Rights Council, Son Excellence l'Ambassadeur Baudelaire Ndong est là, who will make some brief remarks before we hand over to our moderator, Professor Bianchi, and really get the event underway. Once again, thank you very much indeed. Secretary General.
Excellencies, distinguished human rights officials, ladies and gentlemen, I thank the European Union and the Italian government for this commemoration of the World Day Against the Death Penalty. Since the General Assembly adopted its first resolution on a moratorium 7 years ago, more states acknowledge that the death penalty undermines human dignity. It fails to deter crimes more than other punishments. Abolition, or at least the moratorium, contributes to human rights. The taking of life is too irreversible for one person to inflict on another. We must continue arguing strongly that the death penalty is unjust and incompatible with the fundamental human rights. I urge leaders where the death penalty still is used to legally commute or pardon death sentences and to impose moratoriums on executions. The death penalty has no place in the 21st century. I call on states that have not yet done so to ratify the second optional protocol of the International Covenant on Civil and Political Rights, aiming at abolition of the death penalty. I hope to see many more ratifications during the protocol's 25th anniversary this year. The United Nations will continue working to end this cruel punishment.
Dear organizers, Mr. Moderator, distinguished panelists, Your Excellencies, ladies and gentlemen. I thank the European Union, the Permanent Mission of Italy, the Graduate Institute for organizing this event on the occasion of the 12th World Day Against the Death Penalty. I also thank the organizers for providing an opportunity to launch the publication that you might have seen when you were entering, entitled Moving Away from the Death Penalty, Arguments, Trends and Perspectives. It was published by Office of High Commissioner for Human Rights a couple of days ago, and thank you for the opportunity to deliver the keynote address. Why yet another book about death penalty? The answer is simple. As long as the death penalty exists, there is a need for advocacy against it. This book provides arguments and analysis, reviews trends, and shares perspectives and good practices on moving away from the death penalty. The publication offers solid scientific evidence that supports abolition of the death penalty. Although it is an advocacy book written and edited by committed abolitionists, it clearly distinguishes between facts and values. It encourages everyone to choose their own stand on the death penalty based on reliable information. I must acknowledge the worldwide progress made towards abolition since 1948, adoption of the Universal Declaration of Human Rights, which asserts the human right to life. Back then, 66 years ago, only 14 countries had abolished death penalty, and if someone from the audience is from Latin America, you will certainly appreciate to hear that most of them were from Latin America. Currently, 160 countries in the world have abolished the death penalty in law or practice. The support for abolition resonates across regions, legal systems, traditions, customs, and religious backgrounds. Year and after year, more countries are turning away from the death penalty. This is also reflected in the increasingly wide support to the annual, biannual now, General Assembly resolution calling for a worldwide moratorium of the death penalty. Yet I will not hide the fact that currently there are also setbacks, such as when some states resume executions after decades. In addition, there have been isolated instances where states have reintroduced the death penalty. In 2013, after many years of slow but steady and consistent moving away from the death penalty, we have had a 12% increase in the number of registered executions. I'm saying registered executions because some countries are not registering the executions. So when we compare 2013 to 2012, there was a setback. It's 12% of increase of the registered execution. Most unfortunately also, the number of executing countries has also increased by one. Exactly for this reason, we need to continue and even strengthen our advocacy for moratorium, ultimately leading to universal abolition of the death penalty. The publication that we are launching today addresses the main reasons why the death penalty should be abolished. First, wrongful convictions. No legal system is immune to mistakes, so to execute people is too final to be acceptable. Even the most developed, well-functioning and robust legal systems, those with multiple judicial safeguards, have put to death penalty scores of individuals who were subsequently proven to be innocent. Second, deterrence, or the lack of it, as a permanent representative of Italy rightly pointed, there is no reliable evidence that there is any deterring effect of the death penalty. Some member states have been insisting on the death penalty for their own specific crime prevention reasons. Some claim they need it to fight terrorism or to fight drug trafficking. However, I repeat, there is no conclusive evidence of any deterring effects of the death penalty. Then it is also the issue of discrimination. Who is being executed? It's usually members of the marginalized social groups. Almost all executed are poor, and most of them belong to ethnic, national, or religious minorities, or to other vulnerable groups such as migrants. Another disturbing aspect of the death penalty and executions is that people with mental or intellectual disability continue to be executed. This issue is the theme of this year's World Day Against Death Penalty. While we oppose to the death penalty absolutely, we are also concerned to see that so-called existing minimum safeguards are not yet fully implemented. Among these is the requirement that persons with mental or intellectual disabilities should not face death penalty. Perhaps this year, UN General Assembly resolution on moratorium may address this issue. Ladies and gentlemen, some argue that we need the death penalty as justice for victims, for their families. However, in practice, it doesn't look that way. And I'm sure that Mr. Garcetti, who is a panelist today and who is one of the contributors to our publication, can tell us something more about it. First of all, many victims do not want revenge, but prefer justice without revenge or retribution. Research shows victims want to be heard, to share their recounts of loss and grief, but also ways in which they began to recover some equilibrium in their lives and ways to honor the memory of their lost family members. Secondly, the ones who do want revenge do not really get it, because if you want to avoid mistakes and miscarriages of justice, those are long, long proceedings, and in the end, very, very few people get executed in most systems. From some states and their leaders, you may hear that it is public opinion that demands death penalty. But that's the question of leadership. Human progress does not stand still. Popular support for the death penalty today does not mean that it will still be here tomorrow. There are undisputed historical precedents where laws, policies, and practices that were inconsistent with human rights standards had the support of majority of the people, but were proven wrong and eventually abolished or banned. But this requires proper leadership. 2 weeks ago, on 25th September, we organized a panel of heads of states and government consisting of leaders who have helped their nations or their regions to move away from the death penalty. And this was a unique opportunity to learn more about experiences and strategies regarding moratorium and abolition and the leadership required to make it happen. All these themes are captured in the publication that we are launching. It is a part of global action to encourage moratoria, leading to global abolition of the death penalty. I strongly believe that one day people will look back and wonder how it was possible that the death penalty ever existed. Just like in most societies today, it is already hard to understand how slavery could have ever been allowed. I hope that that day is not far away from us. All of us can contribute so that it comes sooner rather than later. Thank you. Yeah, it's hidden somewhere.
Dear Assistant Secretary General, Ambassador Mauricio, dear panelists, it's my great pleasure to be part of this celebration today in both hats, in my capacity of President of Human Rights Council and as Gabon ambassador in the UN to Geneva. I think I'm not going to take longer because I want to learn from panelists. I know that they have so much thing to teach us today. Let me just say that since the adoption of the Universal Declaration of Human Rights in 1948 and the International Covenant on Civil and Political Rights, which assert the human right to life, progress has been made toward the abolition of death penalty around the world. The question of moratorium on the use of death penalty was also brought in the GA program of work through the relevant General Assembly resolution, which you may well know, the 62/149 of the 8 December 2007, 63/168 of 18 December 2008, and the 65/206 of the 21st December 2010. Today, we have more than 154 states of the United States which have abolished death penalty or set a moratorium, and in more than 174 countries. This question was introduced in the former Human Rights Commission agenda in April 2005 through Resolution 2005/59. Since then, many decisions and resolutions were adopted by the Human Rights Council, acknowledging the Council's interest in holding national and international debate on this issue. Most recently, the Council adopted Decision 22/117 to convene a high-level panel discussion on the question of death penalty with the aim of exchanging views on advanced best practice and challenges relating to the abolition of death penalty and the introduction of a moratorium on execution, as well as on national debates on process or whether to abolish the death penalty in the Human Rights Council. In June this year, at the 26th session, the Council adopted a resolution establishing a biannual high-level panel discussion to exchange views on the question of death penalty. I can also remind you that during the 25th session in March, we had the panel discussion on death penalty, where we were honored to have the presence of one of, I can say, the man which is in this book published today, Mr. Kirk Blosswood from the US, who really testify how it was important to abolish death penalty. In my capacity of ambassador of Gabon, let me say that in the Africa, so many countries are working to little bit emphasize on the abolition of death penalty, and my country is among those countries. I think we first were a little bit reluctant to go to the abolition work because some of them was observed what we say a de facto moratorium, because they have law in the internal law to which was processing the abolition, processing the death penalty, but this death penalty was not implemented. In fact, it was not implemented. So my country has signed the International Covenant of Civil Political Rights aiming the abolition of death penalty in 2007. And last year, we signed the second protocol, which permit us to little bit emphasize on the the respect of dignity of the human dignity. Also, similarly, the AU Gabon has joined the appeal made by the African Commission of Human and People Rights at its 49th session in 2011. So I can just say that to conclude this question, that admit no ambiguity. No study has demonstrated that the death penalty has a real impact on crime. Life is the most precious good, and nobody has a right to deprive one from it. I thank you very much.
Good evening, ladies and gentlemen. I'm Andrea Bianchi. I'm the head of the International Law Department here at the Graduate Institute. I have the honor and the pleasure to be chairing this roundtable. No, it's not a roundtable. We have two small roundtables, but it's more of a panel. That's the word I was looking for. I wonder why the organizers decided to ask me to do this, and that's the kind of question you don't ask because you are too afraid of the answer. I thought to myself that it might be due to the fact that I have moderated similar debates on equally intractable problems such as terrorism. Because let's face it, it does remain a difficult debate to be speaking about the death penalty, even nowadays. It's a debate which is heavily affected by our own deeply rooted beliefs, our emotions, our convictions, our presuppositions, and why not also by our cultural biases. But wherever you stand on this debate about the death penalty, I think it can hardly be denied that recently there has been a trend to look at the death penalty as being no longer as a suitable instrument of criminal law enforcement policy. And this is particularly so, as it has already been reminded by some of the previous speakers, in this part of the world. And I'm not just talking about the countries that belong to the European Union, but particularly of the Council of Europe space. It would be a mistake, however, to believe that this is a trajectory of unhindered progress towards the abolition of the death penalty, a direction in which the world is naturally heading. There is absolutely nothing natural about this process. It does remain a difficult journey, one which is punctuated by all sorts of difficulties, particularly from the perspective of retentionist states. We tend to underestimate the effort and the difficulties that these states might encounter even if they were to decide to abandon the death penalty. Governments and decision makers face powerful narratives that are out there and that are favorable to the death penalty, and various kinds of arguments that are policy-based and that ought to be discussed if one wants to open up the debate in the domestic constituencies within states. If the culture has to be changed, these kind of narratives need to be countered, and arguments and counter-arguments have to be weighed and considered effectively. What are these arguments? This is well known, particularly among specialists, the idea that whether or not to have the death penalty in one's criminal legislation is a matter that pertains to a state's domestic jurisdiction, the idea that the abolition of the death penalty is tantamount to impunity, as if criminals would set free if they are not executed, the importance of public opinion, which is almost invariably favorable to the death penalty, or the idea that to abolish the death penalty would be some sort of disrespectful act towards the victims of the most heinous crimes. And this narrative is not redressed or altered even by judicial errors that very frequently occur. It's today's news that an inmate in the death row who spent last 4 years in the death row in Texas has just been exonerated and was able to walk free after 9 years, 4 which spent in death row, because it was eventually ascertained that he was 1,000 miles away from the crime scene. But not even judicial errors, as I was saying, help a great deal in countering all the other arguments that are invoked to retain the death penalty. So that's precisely what we would like to do tonight. We'd like to address some of these concerns and try and provide arguments, insights, counter-narratives that can be used by governments and by decision makers within domestic constituencies, particularly in those countries and contexts in which the retention of the death penalty might be called into question. And we are going to do this in this setting, which is an academic, free setting, not a political or otherwise constrained setting. And luckily, I'm not alone in doing this, but I have a fairly impressive lineup of panelists, which I would like briefly to introduce, and I'll briefly revert to them. I'd like to start with Sir Nigel Rodley at my far left. Hello, Nigel. Who is a professor of international law and the director of the Centre for Human Rights at the University of Essex, and also the chairperson of the Human Rights Committee, the International Covenant on Civil and Political Rights monitoring body. And then we have Gil Garcetti at my right, the former district attorney of Los Angeles County. And then we have Dr. Mai Sato from the Center of Criminology of the University of Oxford, and then Judge Anna-Sophie Greve, who has a wide experience in the bench, both domestic and international, currently a member of the International Commission Against the Death Penalty. So if you're ready to start, I would just throw the first question out there, and I would like to address the first question to Sir Nigel. And the first question, let's indulge our professional bias, Nigel. We are international lawyers, so let's have a look at the legal framework. What is the legal framework, particularly for retention states? What is the margin for manoeuvring there?
Thank you. Can everybody hear me? Yeah, thank you. Well, it's clear that general international law does not outlaw the death penalty per se. However, certainly for states parties to the International Covenant on Civil and Political Rights, Article 6 of which deals with the right to life, it's often not realized how much of an abolitionist document it is, even though we're now celebrating or commemorating the adoption of the 25th anniversary of the adoption of the optional protocol, the second optional protocol to the Covenant on Civil and Political Rights, aiming at the abolition of the death penalty. Because clearly the Covenant did not abolish the death penalty. How much maneuver did that then give abolitionists, retentionist states? Well, as far as the Human Rights Committee is concerned, not a lot. Article 6, paragraph 2 of the Covenant, which does preserve the death penalty, it starts out with the words, in those states that have not adopted the death penalty. It's already couched in terms that seem to think of retention as aberrant. And indeed it goes on in paragraph 6 to say nothing in this article shall be invoked to delay or to prevent the abolition of capital punishment by any state party to the present covenant. And from its very beginnings, as early as its general comment in 1982, the Human Rights Committee has taken the view that the covenant is not neutral, that indeed, in its words, abolition is desirable, quote unquote. Committee practice has certainly been consistent with that approach. It always encourages abolition with states parties that are retentionist. It always encourages, of course, since its adoption, ratification of the second optional protocol. And of course, it always welcomes ratification of the protocol. It also welcomes moratoria, but looks to then the next step of ratification. It has also interpreted the provisions very narrowly, so that the provision in Article 6 that the death penalty should be reserved only for the, quote, most serious crimes, unquote, has effectively been interpreted by the committee. At least this is the conclusion of the previous special rapporteur on summary and arbitrary executions, Philip Alston, that in fact the committee is only going to find that a crime involving death would even begin to fit within that category. It has always also interpreted, there's an obligation in Article 6 that it has to be consistent with other provisions of the Covenant. Well, other provisions of the Covenant include the right to a fair trial. And again, in death penalty cases, it interprets particularly carefully that particular provision. So it's going to be very tough on incompetent lawyering. It's going to require lawyers available at all stages of the proceedings and so on. Perhaps a level that it wouldn't necessarily require for all kinds of offences. I can only think of one case, and I'm not going to name it because I don't recall its name, where the committee didn't find a violation. And my recollection is that it didn't find a violation in respect of an execution that had taken place, and where the author of the communication, who I think was a family member, just simply wasn't able to provide enough information on the case to permit a conclusion that it was in violation. Meanwhile, and I'll stop on this one in terms of committee practice, but I'd be happy to come back on general international law if you wish. The committee, in only one case, has actually changed its practice explicitly. Its view had been, in a case called Kindler against Canada, that it was okay within the Covenant, permitted by the Covenant, for Canada to return a person to California, I think it was, or Pennsylvania perhaps, either way, to the United States to face capital charges. In a later case, Judge against Canada, the committee explicitly reversed itself and said that as far as an already abolitionist state like Canada is concerned, it can't. Why not? Because of those words I mentioned right at the beginning. The right to do so is only exercisable by those states who have not already abolished the death penalty. And insofar as Canada had, and Canada was potentially involving itself in the carrying out of the death penalty by cooperating to send somebody to a situation in which they face the death penalty, that would be, was a violation of the Covenant. So a very strong abolitionist tendency in the committee, but obviously much better in respect of states that ratify the second optional protocol. We've never had a case of a state violating the commitment not to execute people under that protocol.
Well, thank you very much. If I just may insist slightly more on the role of the Human Rights Committee, that admittedly has a difficult task. It's not like the European Court that operates in a context which is death penalty free. So I suppose, you know, the committee has to do with different sensitivities that exist in a much wider community. What made it possible, the reversal of Kindler within the committee? What were the sort of sensitivities or cultural elements that allowed a fairly bold move?
That's a very interesting question. Basically, a minority became a majority. There was a dissent in Kindler. Several members of the committee dissented. And as with many courts, the membership changes. And I would be hard-pressed to explain it member by member, or even to remember exactly who was on the committee for Kindler and who was on the committee for Judge. But I also think it's a reflection of what we've already heard today, the growing consensus that the death penalty is something that simply is very, very difficult to justify under international, under common standards of, evolving standards of what ought to be considered to be the right to life. The very idea that nobody challenges the committee's conclusion that corporal punishment is incompatible with Article 7 of the Covenant, and yet somehow it's, in principle, it's supposed to be able to find putting somebody to death compatible with the Covenant. That goes against the grain, and as the abolitionist consensus evolves, it's probably easier for colleagues to go that route. I'm not sure I can take it further than that.
Thank you very much. May I now turn to Gil Gassetti? I'd like to take up with him the California Proposition 34, the end of the death penalty initiative, just a couple of years ago. Can you share with us, the stakes were higher, obviously. I mean, the example that California might have set would have been, I think, tremendously important for other states to follow suit in the United States. And the end result was quite tight. So can you share your experience? How did you live through these particularly intense, also political and I suppose emotional experience of the proposition?
I think for those of you in the audience who do not know, in California, as in other states in the United States, you can have two types of laws. There are two ways to make laws. One is through our elected legislature, and the other way is by what we call initiative. If you get enough signatures from the populace, you can actually get this question, for example, Proposition 34, on the ballot. And then it's a majority vote, and that's the law. And it cannot be changed or amended unless there is another initiative. It cannot be changed by the legislature. It cannot be amended by the legislature in any way. So what we had in 2012 was Proposition 34 that would have changed. We don't use the word abolish. We say we change the death penalty to life without the possibility of parole. There is such a sentence in California already, life without the possibility of parole. In 1978, when Californians voted to reinstate the death penalty through initiative, this was after our Chief Justice and California Supreme Court had declared that the death penalty was cruel and unusual punishment and therefore unconstitutional. So everyone who was sitting in death row at the time with that kind of a sentence was now going to what we call the general population prison, and they could be eligible for parole. But in that election, in 1978, a little over 70% of all voting Californians voted in favor of the death penalty. Now, fast forward to 2012. We were trying to do something that everyone said was impossible, and that is change the law. Though we didn't quite make it, out of approximately 11 million votes, if we had changed a little more than 250,000 votes, there would be no death penalty in California today. 52% voted to retain the death penalty, 48% voted to change that death penalty. And the reason that we frankly lost was because we ran out of money. We didn't have the money to continue to convey the facts to the citizens of the state of California. You would think that politically conservative people would be in favor of the death penalty, and many of them are, and on the political liberal side would be opposed to the death penalty. Most of them are. But what was so interesting for me was once you started presenting evidence, facts, let's say it that way, facts about the death penalty in California to potential California voters, their eyes opened up. You can almost see them leaning back like, I didn't know that. I didn't know that. Oh, I never knew that. What? Why are we spending this kind of money? What? How many people have been found innocent who are on death row throughout the country? Did not know that either. Oh no. I can't see any purpose that we continue to spend this outrageous amount of money. So I will vote to change the law. And that's what was happening. But literally, about 2.5 weeks before the election, we just ran out of money to get the word and the facts out. The law is going to change in California. It may change as quickly as in 2016. Once California, that has a population of 37 million people, changes, you will see many other states who have not really considered changing their laws. They will start the change. And I think, given the size of California and the importance it has in the nation, we also have a little international clout. Maybe I'll even visit Japan, because they had told us, when the United States gets rid of the death penalty, then come and talk to us. Well, we're not quite the United States, just the state of California. But nevertheless, I think there can be a very significant argument made to the Japanese at that point.
Well, thank you very much. The second question I'd like to address you, Mr. Grassetti, and I hope you don't consider it as inappropriate, has to do with your own personal convictions, because now you are an advocate against the death penalty, but you have changed your mind about this. And if it's not too much to ask, could you share with us some of the reasons that prompted you to change your mind about it? Because I think that personal experiences are just as important as worldwide campaigns.
I'm happy to answer that question. When I spoke at the United Nations a few months ago, I started by asking the representatives of the member states. I didn't do the normal type of Mr. Secretary General, etc. I just said, I'm taking a vote. Raise your hand right now, and I'm going to do it right here, the same way. Raise your hand if you've ever had the opportunity to engage the person who had ultimate decisions on death penalty cases. One person. Okay. Well, I was that person. I was that person in the district attorney's office. As the elected official for 8 years and 4 years as a chief deputy, I had that decision-making authority, and I did support it. We were talking earlier when people asked me when I was district attorney, do you believe in the death penalty? And I said, yes, the way my county effectuates it. I will not speak for the rest of the state, because I know there are some counties in the state of California that I would not support how they use the death penalty. Of all the cases where someone becomes eligible under the law for the death penalty in California, but in the county of Los Angeles, we sought the death penalty in less than 15% of those cases where someone was eligible. And so I was satisfied where we were with that. Wasn't sure about the deterrence, but these were the most horrific of horrific cases. And it was some years after I left office. I left office in December 2000. And about 8, 9 years later, I began to look at this and something's wrong with this. And then there was a federal court judge, appeals judge, and a law school professor who did a 3-year study on the death penalty in California, and they gave me information I'd never had before. Literally the billions of dollars that are spent on the death penalty. That was number one. And then, again, hearing about the number of innocent people on death row, not just like in Texas or Louisiana, but these are, quote, progressive states like Illinois and Pennsylvania, New Mexico. That really affected me. And then as I started looking into this, I see the literature that everyone's in agreement. There's no proof that the death penalty is a deterrent. So what useful purpose does it serve? Revenge? Is that a useful purpose? Can we afford that? Should we? My answer was no. And so I went public. I wrote some articles, some opinion pieces, and started working very hard. because I am convinced, as of this morning, there are 750 men and women on California's death row awaiting execution. 750. No one in this room should be satisfied that there's not at least one innocent person there, and there's probably many more. Prosecutors make mistakes. Juries make mistakes. Judges even make mistakes. But when you make a mistake about someone who's on death row and is executed, you can never solve that mistake.
Thank you very much for sharing this with us. May I now turn to Dr. Maisato from the University of Oxford. Dr. Maisato is a social scientist who has conducted some very interesting fieldwork in Malaysia and Japan, and we spoke briefly before the panel, and she's ready to share a few slides with us. So I suggest we start from there, and then perhaps we'll ask some questions later.
Talk briefly about public attitudes and the death penalty. I think we often take sort of survey results at face value when, for example, governments use them to say that, or the public supports the death penalty, therefore we can't abolish. And I think the debate also, at least in the legal literature, seemed to focus on principle. So whether public opinion is relevant in the death penalty policy rather than on the quality of public opinion. And I think from a social science perspective, there are many factors that influence the survey results. And what I want to do today is to simply showcase 3 examples where this is the case. And I will use 3 data sets. One is from the Japanese government survey, and one is a survey that I've conducted in Japan, and the last data is on the Malaysian public opinion survey. So I'll start with the Japanese government survey. The most recent state party report that the government submitted to the UN Human Rights Committee, they used their own government survey and quoted that 86% of the Japanese public support the death penalty, therefore they can't abolish. And what we often don't do is to actually look at the survey question. So this is the survey question that the Japanese government uses. Basically gives 2 options. One is, the first option is the abolitionist option, which is phrased, death penalty should be abolished without condition. And the second option is the retentionist option, which is death penalty should be allowed according to circumstance. And what we see is that we have a very narrow definition of abolitionist and a very wide definition of retentionist. And this is how we get to the proportion of 86%. The next example is the knowledge of respondents. And for this, I want to share the survey that I've conducted in Japan. What I did is to ask the survey company to give me 2 equal samples. What I mean by equal is equal in terms of distribution of demographics, so sex, age, education, but also death penalty attitudes. So they were equally distributed. And in one group, in the experimental group, I gave them information ranging from world trend towards abolition, the relationship between deterrence and the death penalty, possibility of wrongful convictions, and the other group, which is referred to here as the control group, no information. And I asked both groups the same question: what are your views on the death penalty? 2 things in this slide. The first is that across all death penalty views, you will see that the group with information supports the death penalty less. And one surprising finding was that those who thought that the death penalty should definitely be kept, so those who are committed retentionists, the information had the most effect. So even though on surface you may think that they're committed retentionists, those were the ones who are most malleable to information. So the last example is when conducting surveys, I think it's important to put the death penalty in context and in perspective. So this is an example from the Malaysian public opinion survey. We asked to rank the importance of policies in reducing violent crimes leading to death. And as you can see at the bottom, that's the option for the death penalty. What we see is that, so more stars, more popular, less stars, less popular. So what we see is that the death penalty option was the least popular policy option. But what's also interesting is that in the same survey, we also asked a general question about the death penalty. Do you support it or not? And those who answered, yes, I support the death penalty, amounted to 91%. And this is why I say it's important to ask the question in perspective. I think, and the same analogy can probably be made with tax. If you ask people, do you like paying tax? The answer is probably going to be no, but we all know that what tax is used for. So when you ask the question in context, you'll see a different view. So I've introduced 3 examples where surveys, the way in which you ask and the quality of sample determines the result. And I think that the question that follows from this is, does public opinion matter? Isn't death penalty a matter of human rights and not of public opinion? And here, as a social scientist, I just want to offer a very short summary of my view. I think it's a very bold statement to dismiss public opinion completely when we talk about any policy. And I think the interdependence of law and public opinion and the need for legal systems to command popular support has long been recognized. So I don't disagree with using survey as a social barometer. In fact, I think it's a very useful thing to do when done properly to inform us about public policy preferences. But, and this is a very big but, that if governments want to continue relying on public opinion, the evidence must be sound. And often what is termed as public opinion is made up of badly formed questions, answered by ill-informed public and not so good quality sample. And in that case, it is not a good basis to justify retention. And I just want to finish off with a couple of dissemination. We've brought a couple of reports. If you're interested in the Malaysian Public Opinion Survey and the death penalty in Japan, they're both available online for free. And if you are interested more about public attitudes to the death penalty in Japan, you could also purchase my book, but I also brought some free copies along with me today. And I also brought with me the recent report we launched in March on wrongful conviction, which was funded by the UK Foreign Office and co-authored by the Death Penalty Project. And I brought 40 copies, and it's available at the entrance. Thank you very much.
Thank you very much. This is most interesting to learn. Indeed, public opinion matters. Public opinion is voters, so to governments and decision makers, public opinion must matter. But what's troubling is that, as you say, public opinion provides the answer that the question probably prompts. So it very much depends on what you ask. The results heavily depends on the formulation of the question. So if you were to suggest, let's suppose that there is a retentionist state that would like to undertake the path of abolishing the death penalty, what would you suggest lawmakers do in terms of how to play with polls and surveys?
I think my view is that what we need to measure is public tolerance for abolition, public acceptance for abolition, rather than simply looking at proportion. Is 50% enough or 60%? It's more tolerance and abolition, because in theory, I don't disagree with the argument that if a state A abolishes the death penalty, having a death penalty is so central to the legitimacy of the criminal justice system, abolition would erode all of that and people will take justice into their own hands. Of course, that's a situation we want to avoid. But if the public views abolition as legitimate, and they may not be happy with it, but if they're happy to accept, I think that should be the measure. And in that way, the governments and the ministry can exercise leadership as well as being responsive to public demands.
Well, thank you very much. Let me now turn to Judge Guede. I was thinking, we are 4 lawyers in the panel, which is far too many for my taste, but lawyers are supposed to be mere executioners of rules. But this discussion is also about something else. It's about values. It's about what you believe to be just. It's a much broader discussion. So perhaps we should broach this issue. The discussion about the death penalty is also about a discussion of the values we give priority to. It's about human dignity. Would you agree with this?
Absolutely, and I'm fascinated to be able to address this aspect. I'm fully in agreement with all my colleagues in the panel. I indeed favor facts. I favor facts being communicated. I'm mindful of the fact that there can be injustice. It's frequently injustice, but it could also be just in the sense that we are not always mistaken. It could be someone who would not be discriminated against, and it might perhaps serve as a deterrent. Although we have facts to not being able to prove this. But even in such cases, we had in my country in 2011 a young man. He was not from a minority group, he was not underprivileged, and he killed some 80 people. And he was caught red-handed. And no one would think that if he had paid the ultimate price by having the capital punishment, that would have been injustice or discrimination. But still, the people did not want this. And then we come back to what, in my opinion, is perhaps something that's even missing in this wonderful book. I fully appreciate the book. I appreciate that there is a distinction between values and facts. And I appreciate that values may be more difficult to approach. But what I think we need to do, and this is where I think we can renew the fight against the death penalty, that's by opting for a culture of life. We need to enhance human dignity. We have to upgrade the value of ordinary life of everyone. We have a need for a kind of renaissance in terms of humanism. I would like to write to you what one of the founding fathers of the Universal Declaration of Human Rights once wrote. He said, "It's not enough to be," this is for the right to life, "it's not enough to be free to be what you are. You must also be free to become what your conscience requires you to become, in light of your best knowledge. It's therefore freedom of becoming, of change, that we stress as much as freedom of being." And it's actually the young man in Norway who killed so many. He said, "I want and I only respect the death penalty." He called for the death penalty. But the people said, "No, absolutely not." And it was the people in Norway who actually abolished in the early days of the 20th century, they abolished the death penalty. They did not want it. It did not fit with their approach to life, the meaning of life, the dignity of life. I think, although it's very difficult to give facts, what's the human being? We can leave that for the medical sciences to describe. But it's more important to ask, who is the human being? That is to say, what's the potential, the mystery of each and every one, irreplaceable, cannot be reproduced. And we cannot only leave this to religious faiths to ponder and to look at. We all need to address this basic question. It's not so much in favor at this time to look at such kind of difficult questions, but still this is where we have to return. In my opinion, the very reason for the UN, the European Union, the Council of Europe, is human dignity, the quality of each and every individual. And if we try to address this, if we try to upgrade life for everyone, to see everyone, to seek also social justice, we can, I think, diminish crime, and we can include more people in our societies, and we can have better qualities of life for everyone. And this must be our main objective. And I think the facts supports this. Yes, I agree with everything that's said. At one point in time, I investigated war crimes, genocide in the former Yugoslavia, and I looked at the Khmer Rouge. I have spent endless nights talking with people who have told me how they executed hundreds and more. They are all people. We need to look at life, the quality of life, the dignity of life, and the possibility of change, and to become something more and something else.
Well, that's a powerful call indeed. Given your wide experience as a judge, and you recalled some of your past work also at the international level, it is difficult to be in the bench, particularly when you have to judge whether or not to impart the death penalty. So, do you think, is there anything that we can say to those who are in charge of this? I mean, your appeal to human dignity and to the importance of the individual, but the judge operates in a set of constraints. You know, what would you feel like telling your colleagues, your fellow judges all over the world who have this responsibility, who have this burden of deciding whether or not to impart the death penalty?
For one, personally, I wouldn't want to be on a bench if the death penalty was an option. But one thing that to me is very significant is that I see no distinction between the role of the judge and the executioner. And the executioner is not exactly well regarded in most societies, but the judge is. But I think that only comes to the fact that people has not really been looking at what are the different roles. Without the judge, there will be no executioner. So maybe the supreme responsibility rests with the judge and the legislators.
Well, thank you very much indeed. Apologies to the audience, I miscounted the lawyers in the panel. It's 5 out of 6. As Mr. Simonovic is a professor of law, so
and former Minister of Justice.
Former Minister of Justice. Indeed, far too many. The purpose of the evening is to have an interaction. So I think you're looking forward to asking further questions to our distinguished panelists. So I'd like to open the floor. But before doing that, I would like to remind you that this is an academic-free setting, so feel free to speak out. The only limit I would like to impose is that whatever you intend to say, which I hope will be respectful, you have to keep it under 2 minutes, please. As my students keep reminding me, the more you speak, the less you are listened to. So I think it's a golden rule. And please introduce yourself as you take the floor. There is a lady there with the mic and the gentleman here in front of me. So I would like to break the ice and ask the first question. Please feel free to address your questions to any of the panelists. Yes, the lady right there.
Thank you. My name is Nicole Wirsch. I'm a Swiss diplomat. And I have actually 2 questions, to the panel. I want to take this opportunity. I deal a lot with the death penalty as a diplomat, and I encounter different colleagues from different countries, especially retentionist countries, and some are especially difficult. I want to raise the case of Singapore. Singapore is very proud to tell us that yes, there is a deterrence effect, and it is applying the death penalty mainly to drug traffickers. And it is so proud, and it says, we have the task to protect our population. See, we are one of the only country in the world who managed to do that. We don't have these slums with all these drug addicts, and for us it works. And it is difficult. I mean, to me it seems selfish because Singapore is a very small country also. I mean, I have big doubts, really big doubts, that the death penalty or a purely repressive method has led us anywhere in terms of fighting drug trafficking at the global level. So I don't like this argument, but with Singapore itself, it's very difficult to fight. So I'm just keen if you have some reaction and tips to give me on that. Excuse me, and just a small reaction to the last speaker, Ms. Greve, regarding the importance of life and the options of culture of life. And just, I want to give a feedback because this happened to me this week. I had difficult démarche to make towards a country from a country who's executing. And I think my interlocutor had some sympathy for what I was telling him. And at the end, he raised this issue, and I was really taken by surprise, but I found it interesting. What about the high suicide rate in Switzerland? You know, I mean, somehow people here are taking their own life. And somehow I was so unprepared, you know, that he actually hit really the right topic where we can work upon, you know, the value of life. And I just wanted to give this feedback because I was kind of so surprised myself, and I think this is important. Thank you.
Who would like to take this one? Judge Graham?
Yes, because I appreciate that Singapore is proud that they don't have a drug problem. But I might want to invoke an Eastern saying. They call it the roaster fallacy. That is, the roaster is waking everyone up in the morning and thinks it is because it's doing so that the sun is rising. And I wonder if Singapore wouldn't come to the same result if they had life imprisonment without pardon. I mean, it's a suggestion, I don't know the answer, but maybe it would be worthwhile trying. And Singapore is like a city-state. As you said, it's a relatively small country. But I would invite Singapore to try an alternative and see if that doesn't work equally well. Otherwise, there could be a roaster fallacy. Thank you.
At our event on 25th September, we had in the audience Minister of Foreign Affairs of Singapore. And he asked for the floor, and he was just sharing with the audience arguments that you mentioned. And afterwards I approached him and drawn his attention to a wonderful study, and I think that some of you, I mean, you probably know about it, A Tale of Two Cities, comparing Singapore and Hong Kong, rather similar, culturally similar, traditionally similar settings, one having and one not having death penalty, as well as following Singapore, who they were executing or non-executing a lot in different years. And the study was concluding that there was no deterring effect, whether they were executing a lot or not. And when comparing years when Singapore was executing or not, there was no deterring effect visible of increased execution, and the same when comparing a similar setting in a country that is not executing and executing. So when I said that, he said that we need to discuss that. So to be continued.
Thank you. Just to unpack this sort of slightly technical sounding special deterrent effect, it's a version of exactly what the rooster story from Judge Graver, and what philosophers who like Latin, as lawyers do too, call the post hoc propter hoc fallacy. that because one thing happens after another, therefore one thing has caused the other. The most likely, I suspect, a reason for the alleged effectiveness of the death the death penalty, or of the repression of drug traffic. Incidentally, there are many other countries where the death penalty is used and it doesn't seem to succeed, is that they do have efficient police, and they do detect, and they do bring to justice, and they do convict. And the issue about the special deterrent effect is whether or not that isn't the deterrent rather than the death penalty as such. And the whole point about studies about the special deterrent effect is that as often as not, the reason there's little evidence of the death penalty in fact deterring is because there are other factors that lead people to take the risk, like the unlikelihood of being caught. It's certainly true that terror might work also, and I have no doubt that if everybody who committed a crime was subject to the death, any kind of crime was subject to the death penalty, then a sort of peace could be made to prevail. And I would remind people that with Singapore, we're not even talking about necessarily large quantities of drugs that might or might not lead to death. We're talking about small quantities of drugs as well that most certainly would not lead to death, but nevertheless, the disproportion between the penalty and the offence is pretty damned unconscionable. And I, at the risk of maligning the Singaporeans, and I'm not going to be specific that it's necessarily Singapore, but there is an elephant in the room behind some governmental claims, and especially militant governmental claims to want to use the death penalty. And certainly Singapore is militant. And that is that they like having the death penalty to support their authority. Authority finds comfort in having the ultimate penalty as a legitimacy and as a cachet of their authority. That too is a possible reason for at least the militancy.
Other questions? She's right in the middle, so either way.
Hi, my name's Katie. I'm a master's student of anthropology here at the Graduate Institute, and I'm from the state of Virginia in the United States. And I guess my question is really more directed for you, Mr. Garcetti. I guess I'm curious as to why you are so confident that if California abolishes the death penalty, other states will quickly follow suit. I mean, I think we've seen just an example that comes to my mind is the legalization of marijuana in the United States, and Colorado being the first to do so. And it's true that other states have followed suit, but at least before I arrived here at the end of July, it seemed like Virginia was probably going to be one of the last, if not the last, states to do so. And so I'm simply curious as to why you are so confident that other states would follow suit so quickly, because I guess I'm very hopeful that that would be the case, but I think states like Virginia would hold out until the very end.
I don't know how quickly, or I don't know if I said it's going to be done quickly, but it will happen. And the reason I have confidence in this is because facts. If people understand the facts, then it changes. If you tell the residents of Virginia, if there were a study done like in California, this is how much the death penalty is costing you. And this is what you could have done with the money otherwise. Plus, how many innocent people or people who should not be executed on death row are there in the state of Virginia? Now, I can't point to one particular prisoner in California that does, but I just know that counties implement the death penalty in different criteria, and that's very bothersome to me. Even in the county of Los Angeles, whether the district attorney's office is successful in getting the death penalty is somewhat contingent on where in the county the case is tried. Don't forget, the county of Los Angeles is 10 million people. We're larger than 43 states in the United States. And it's spread out tremendously. So you can go into one area where there are courts. There are 1,100 prosecutors, for example, in the district attorney's office in Los Angeles. So if you can put your head around that, I could never, even as district attorney, I couldn't put my head around that. But if you can just picture, the various offices throughout the county, and then a question of fairness, well, if the case is tried here, you mean there's a greater likelihood of getting a death penalty? Yes. Is that fair? Is that equal protection argument? Is the same possible in Virginia? I don't know Virginia, so I don't know. But I think it's when the people get the facts. And I was mentioning it earlier today in a private conversation, that when I went out to speak, the politically conservative were the ones who came across very quickly when they first heard about the issue of innocence. How many people who were on death row throughout the country didn't deserve to be there. That was number one. Number two was the cost. Number three was the fact there's no proof that it's a deterrent. And everyone's concluding, well, then it's just revenge. What good is that going to do? Because when does revenge come? In California, it's a minimum of 23 years, I think, after you've been sentenced to death, that you will actually be eligible for death when you think all the appeals will be done. That's not necessarily the case, but that's kind of the average. So if it's revenge, and people haven't brought up one thing that really affected me too. What about the victim's family? Even if they're in favor of the death penalty, when you explain to many, all right, this is what's going to happen. About a year from now, he will go to San Quentin. And about 5 or 6 years from then, they will have the court record finalized where the appeal process can technically begin. But then they have to find a lawyer. And they can't find lawyers because the state of California doesn't pay much for appellate lawyers. And so then the case goes on. So here you have all the victims who are living in a state of anguish. We can never, ever bring back their loved one. We can never, ever close the door for them. What we can do is give them legal finality. And if they know the legal finality is life in prison without the possibility of parole, then I think you begin to see some of even those people change their views.
Thank you. My name is Vincent Ploton, and I represent an organization based here, which is called the Center for Civil and Political Rights. We are organizing tomorrow, which is World Day Against Death Penalty, another event on the commemoration of the 25th anniversary of the optional protocol to ICCPR on abolition of death penalty alongside the city of Geneva. So I very much encourage all of you to take part in that event. It's taking place tomorrow at the City Hall of Geneva at 7 o'clock, and Sir Nigel Rodley is one of the panelists tomorrow. My question, I think, is addressed to all panelists, and I was very interested by the presentation of Dr. Sato, which related to polls, surveys, and that very fundamental issue of public opinion. As you rightly said, almost systematically, what we hear is that the population is generally in favor of death penalty. And you rightly said, Professor Bianchi, that we have a panel made up of lawyers, which I'm aware of, and I'm aware that we don't have a journalist. But I'd be curious to know, in the experience of panelists, whether they have and how they have engaged with the media on the issue of death penalty. I think the media have a very clear role to play in terms of opinion leaders and opinion makers, and the role that they can play in promoting the use of death penalty. And I would just like to mention one case, a very telling case, which actually took place in Geneva, here. Those of you who are based here will remember that whole awful case a few months ago of one social worker who was brutally murdered by a convicted criminal. And that awful incident prompted a part of the press, especially the populist press, especially the press which is available for free in the public transport, and which we know under these latitudes is increasingly the press that most people read, simply because you can find it everywhere and it's for free. And that press was basically, some journalists was basically calling for the imposition of death penalty. And of course, there was a vicious circle of populist politicians and populist political parties also pinking on that and making the most of that incident to take some room, or find a room in that populist press and call for the imposition of death penalty. So I'd be curious to hear the views of the panelists on whether and how they have engaged with the press on these issues.
So I just want to speak from my experience. When I published my book on public attitudes to death penalty in Japan, I did a book launch at the House of Lords, and we invited all the media representatives, both Japan and English-speaking media. It resulted in a number of newspaper articles, especially in the English-speaking media, because I think the headline goes quite well, that the public doesn't support the death penalty that much, there's legitimacy. So that was easy. In terms of the Japanese media is very conservative in a way that they don't want to criticize the ministry and the Japanese government's approach, and they were right-wing media as well as maybe central sort of on the political spectrum, and it did result in one article. But I did my book launch in January this year, and the article wasn't published until a couple of months ago, and that is only because the Hakamada, the wrongful conviction case, came out, and that gave the media an opportunity to talk more critically about the death penalty. Without that case, I don't think I would have got any media coverage on that. So I think that kind of speaks about how media operates in Japan. And another point is, I think what appeals to the public is cost and wrongful conviction. And I think these are the two factors that perhaps the media can focus more and to influence public opinion.
When we were in the middle of Proposition 34, I was asked to go with two other people to various editorial boards of the newspapers. And one was particularly memorable. It's our state capital, Sacramento, and the Sacramento Bee is the newspaper. As we were being led up the stairs, the person who was escorting us said, "Good luck." I said, "Oh, do I need good luck?" I said, "Well, for over 140 years, they've always been supportive of the death penalty," which I didn't know. I said, "Oh, well, thank you, I'll take that." We went and we met with them, and what did we do? We gave them facts, and more facts. And you could almost see them, when they're kind of like this, crouching down, listening to you or not listening to you, then all of a sudden you see them begin to straighten up. Oh, really? Ah, that's interesting. That's how we started turning them around. They eventually came out in support of Proposition 34. They ran 3 editorials, spaced, and then they had a 5-day series of articles about the death penalty and why the newspaper was changing their lifelong position on the death penalty. It was powerful. Not quite powerful enough, but we were getting there. So that's what has to be done. That's how the media can be really helpful, if you get editorial boards and others to write, and then write factually.
Thanks. Just very briefly, and you just had a masterclass in answering that particular question from Gil Garcetti. It is the facts that work. Your audience is part of the question. If you're trying to reach public opinion generally, then it's the facts, and one just hopes that one gets the media to listen and to disseminate. In my country, you pay for the newspapers that write the sort of rubbish that Vincent was referring to as being available in the country he was referring to. It's a pretty virulent kind of media. But there was one of the facts that's relevant if your audience is through the media, the politicians, and the politicians don't read the cheap stuff, they read the other stuff. It is again a different kind of fact. Subject to correction from Gil, I remember about a quarter of a century ago a study by a couple of University of California social scientists, Zimring and Hawkins, doing a study in which they basically showed that public opinion is almost always against abolition at the time of abolition. And it takes something like 25 years for it to catch up and then not want to introduce it. I don't know if there's been any updating of that study or if it still remains the case. But that is the sort of fact that will appeal. One, it's not generally known, and so it's interesting, as Gil suggests, and it might appeal to the better side of politicians whose better sides aren't always best appealed to.
If I may add, I think you cannot leave the floor to the devil's advocate. You have to come up with serious reporting on these kind of cases. And I think when every one of us, if we have spoken, and when we've spoken to the press, if it's facts-based and you want to address the issue in a proper manner, at least you do not leave this for the extremists to take control. And I think that's very important to do. When it comes to the arguments, I think that varies from continent to continent. I think in Europe, the miscarriage of justice is a much stronger argument, the possibility of that, than the cost issue. And to some extent, Europe is taken aback by the cost issue being at all relevant in this. So maybe we also need to be mindful that the arguments that are most effective may vary from continent to continent.
Thank you. I think that when addressing the issue of best approach to media when death penalty is concerned, we have to acknowledge realities and use windows of opportunities when they occur. I mean, the logic of journalism is that they want to bring something interesting to their readers, something unexpected, something outrageous. So if death penalty is discussed only after some brutal mass murders, then you are always losing ground. So it's much better to use windows of opportunities when we have cases of wrongful convictions or something like that to raise the issue of death penalty and debate. And one interesting example of a lot of media attention as a result of introducing a new technology was DNA analysis and exonerations, which has turned to a very powerful tool for abolitionists.
I may just add a little gloss to this. I think that the media are powerful and they can bring the world to act differently. The two things that come to mind as an international lawyer is the change of attitude of the international community towards the war in Bosnia and Herzegovina, which was primarily prompted by the shift in the media that all of a sudden realized what was going on and start broadcasting horrible things. The same holds true for Rwanda. Surely that led to a belated answer. The genocide had already taken place, but once again the shift in the attitude of France and the Security Council was again prompted by a change of attitude in the media. Perhaps we should also add that all these considerations have been made and applied to free media in a democratic society.
Can you hear me? My name is Graham DeBarra. I'm a graduate of International Human Rights Law from the National University of Ireland. I'm going to stay seated. I hope everyone can see me. I came from my first yoga class, so I don't think I could stand up even if I wanted to, sorry. My question is directed to Nigel. Nigel, I'm very interested in what we can do from a top-down approach, given that we're in Geneva with its robust international forums. You're from the UN Human Rights Committee yourself, and even though I would agree with former Judge Ann's proposal of a bottoms-up, a very much philosophical-driven approach to ending and to improving the current policy of the death penalty. But I would be interested in hearing your own perspective. There are many scholars, including of my own Centre of Human Rights, Damon Barrett, who argue that the global efforts to end drugs and supply of drugs, he calls it a systematic violation of human rights, a direct cause of death penalty in many countries, including China, Singapore, and many more. In 2000, I'd like to draw your attention to the policy of Ireland. In 2011, the Irish state boycotted, from 2011 to today, boycotted the United Nations Office on Drugs and Crime because it indirectly funds money to countries which then militantly cause the death of people who have problems, or not even problems, people who choose freely to consume drugs. So I'm interested in hearing your perspective. Number one, do you think more countries should follow suit in boycotting programs such as the global effort to end drug supply? If it's shown evidently to cause death penalty, and two, do you think it's effective that from a top-down approach, countries could implement, a boycotting of certain member states, that it could be effective to improving human rights internationally?
That's going to take thank you very much. It's a very interesting question, and it's going to take some unpacking, and I'm going to have to do a little bit of sound biting here in a way that I'm not terribly comfortable with. I have no doubt personally that the international drugs policy is the same sort of failure that prohibition of alcohol was in the United States in the 1920s, and that far from solving the problem, it's criminogenic. And to the extent that having the death penalty is some kind of veil of seriousness, which doesn't in fact deal with the problem, is not very helpful. But in terms of presentation, I think it's very difficult to draw those issues out in that way. I would not want to say that in order to argue against the abolition of the death penalty, you have to argue for the decriminalization, or at least the regulation and decriminalization of drugs, pointing out that the death penalty isn't much use in solving the problem, and questioning whether criminalization is any use as well. Generally, it might be worth doing. But it's very important, perhaps, when getting into that debate, not to give the impression that drugs can't be very harmful. As to what you had to say about the UN Office on Drugs and Crime in Vienna, clearly they were against UN policy. Their refusal to speak out, they didn't advocate the death penalty, but they did support states that were using the death penalty. I have a feeling, and I'm on uncertain ground here, that they've retreated from their position of silence, that they have in fact now said something a little more abolitionist at some point. Certainly, you've just heard the UN Secretary General. He wasn't making any exceptions for drugs. He was saying no to the death penalty. So exactly how any other part of the Secretariat should be taking any kind of contrary approach baffles me. I think what I would want to do is just make sure that they fall into line with UN policy, which actually goes back quite a long way, not least to a General Assembly resolution of 1971 calling for the progressive restriction of the abolition of the death penalty, of the offences for which the death penalty is applicable, with a view to the desirability of its abolition. To have parts of the Secretariat somehow hiding from that policy is simply inappropriate, and maybe internal Secretariat procedures could be invoked. Certainly, I can't see how that position is reconcilable with that of the High Commissioner for Human Rights position, or the Assistant Secretary General's position, and their position should not be being undermined by the colleagues in Vienna.
Thank you very much. We are slowly approaching the end of the debate. There is perhaps just the time to take the two last questions, which are like the lady, I think, on this side, or the gentleman up there, and the gentleman up here. Can I ask you, please, to keep it short, so that we can wind up later? Who would like to take first? You?
Thank you. I'm Paolo Cuculi. I'm an Italian diplomat. And 2 years ago, in one of such events, there was a US relative of victims. And I was struck by his witnessing that, I can't remember honestly the state, but his point was that his testimony as a relative of a victim of victims, because it was the whole family who had been slaughtered, who said no to the death penalty as a revenge, had been in his own experience more powerful in terms of advocacy than many statistics about wrongful convictions, costs, etc. Now, I see the point Mr. Garcetti made about the arguments to use with the victims and relatives of the victims, and I'm convinced that this is a key element for advocacy. And I found throughout the whole debate that the part related to how you address the victims of such horrendous crime to be slightly less convincing, or rather excellently convincing in this academic framework. Not so much in some countries. In some countries it takes very little to have the death penalty administered, and there's even mob justice in many countries. And not all public opinions, unfortunately, are as educated as the Norwegian one. So my question is, how do we frame an effective strategy to speak to the relatives of victims? Because this is the strong argument which is used, in particular in the Middle East. How can we convince somebody who said, I'm ready to wait years to get my revenge? Because it's not acceptable just to let go. My kids were murdered, my wife was murdered, my father was murdered. I don't care, I want revenge. The law gives me revenge. I will have it. How do we talk to them?
Can we take also the last question and then revert to the panelists?
Thank you very much. I'm Kok Jui. I'm the Singapore ambassador to the UN. It's fascinating for me to sit in to listen to your views because I just assumed post less than a month ago. I think I'm probably in the minority of one in the entire audience, but it's fascinating for me to understand from your perspective how you view this important issue to you, and of course to us. I think the arguments for my government's stance towards the death penalty, especially on drugs, has been well said by the Swiss diplomat as well as by the panel. I think I just want to make 3 short points. I don't have questions. First is that the Italian gentleman just said that he has seen one victim, of course, say that she rejects, essentially the death penalty as a punishment. But if you speak to many others who are victims of drug abusers, their families, I'm sure they can give you a different perspective. What we are saying from our perspective is that for us, it has so far worked, and this is how we view it. And we hope that Singapore, like other countries around the world, can be given their right to determine how they would like the societies to function, how they would like the societies to be run, etc. So this is one point. The second point I would like to highlight is that we are always constantly reviewing our laws, and the death penalty is not an exception. In fact, in 2012, in Parliament, we made some amendments to the legislation, essentially making death penalty offences that is not mandatory for under very restricted circumstances. For instance, they are couriers. For instance, if they are also helping the investigations, they are not part of the drug trade, or they are mentally not in a position to make good decisions. So we have reviewed our laws, and that amendment to the law has been passed in 2012, and it has been supported by both the party in power as well as all the opposition parties in Parliament. So my point is that our society is evolving. We are constantly reviewing our laws. At this point in time, this still works for us, and we hope that you can respect our decision at this point in time, that this is the best option and one of the legal tools that we have to help us prevent and deter this issue of drugs. So that's my comment. And the quantum is, if you're wondering what is the quantum that can trigger this particular sentence, in layman's terms, the quantum that can trigger this is about, the quantum is enough to supply 300 drug users for one week supply. I mean, this is the quantum in layman's terms. So, I mean, I'll be happy to engage the audience, I mean, after the session, I mean, because as I said, it's fascinating for me to learn from your perspective how you view this issue. But thank you very much for your opinions and your thoughts. Thank you.
Thank you very much. And I'd like to go back to the panelists in whatever order. Would like to take this first. Can I ask you to keep it reasonably short?
I'll try to do this. How to address victims. I have worked a lot with victims who have lost their relatives in genocide, the most serious of crimes possible. And to them, in my experience, there are two things that count. It's truth and it's justice. It's not so much the issue of what kind of punishment. It's justice. Thank you. Sorry.
No, that's all. Thank you. Responding to the Italian diplomat's question, first of all, one of the ways of responding to that line from victims is to confront them with other victims who see it differently. The ones that Gil was referring to, who themselves say, no, we don't want the death penalty. We don't find that will somehow purge our feeling of grief and sorrow and loss. There's also the other element, and it was hidden in what you said. The law gives me the death penalty, therefore I want it. If the law doesn't give the death penalty, then after a while they won't be wanting it. So again, it's a question of political leadership. But ultimately, we've stopped talking about human rights, and this is a human rights issue. It's no longer just an internal criminal policy issue. It was at one time. It isn't anymore. It's a human rights issue. It's the right to life. It's the right not to be subjected to cruel, inhuman, or degrading punishment. Those are the principles at stake, and those are the values that are the underlying values that are increasingly being applied to the death penalty, and have certainly been very firmly applied to the death penalty in the context of the United Nations and in the context of the protocol, second protocol to the Covenant. Thank you.
My expertise, if there is any expertise, is limited to California. But you raise a fascinating question about the Middle East and how do you approach them. I think maybe there's a lesson from our engagement with victims. You can talk to wardens of prisons, I think throughout the country, my country, and who've interviewed the victims who may have sat in during the execution or very close to, how do you feel? It's rare to see a feel great. Okay, I'm relieved. Most of them at best said, I don't feel any different. So, why have it if, you're not going to be, feeling some relief or some joy, I guess, almost in doing it. That is one thing that we have found, frankly. The other thing is to engage victims in terms of, you're looking for punishment, aren't you? Yes. Well, if this person knows that he or she is going to be in prison every day of their life until they die in prison, isn't that more punishment than being executed? Why in California do so many of the men especially who are eligible for the death penalty hope that we seek the death penalty? Because they know they're going to be convicted. But if they're convicted, then they're going to be on death row, which gives them all kinds of privileges. Now, in the Middle East, maybe there are no such privileges. My guess is that's the case. But nevertheless, I had one woman. Her son was a police officer. He and his partner stopped the car. They got out of the car. It was at night. As soon as they were a few feet, the two officers, a few feet away from the car, the man came out of the car and shot them quickly, came and shot the son in the head. Both killed, both dead. She was demanding the death penalty. This was shortly after I was elected district attorney, demanding the death penalty. And we sought the death penalty in that case. We got the death penalty in that case. About 7 years later, she called me and said, that was a horrible mistake that I made. What? Seeking the death penalty. Because number one, I don't know if he's ever going to be executed, but I live with this every day. And two, if I really want to punish him, he should just stay in prison because then he has to think about it every day. Now in the Middle East and other places, they don't have the delays that we have. Fully cognizant of that. But there's something to learn from the victims' families that maybe could help.
Well, thank you very much. That brings us, unfortunately, to the end of this most interesting panel. I'm very happy we were able to cover so much ground. I think we have discussed thoroughly some of the arguments for and against the abolition of the death penalty. I hope in a thoroughly balanced way. But I'm also happy that we've been able to do so in Geneva. The discussion on the death penalty is most of the time associated with New York. And Geneva in many ways, I'm not just talking about the United Nations, but also Geneva, where there are many other things than the United Nations. It's also the right place to have this kind of discussion. And this is without detriment to the importance of New York, in which I suppose shortly the draft resolution presented by the European Union and the coalition of like-minded states on the moratorium will be presented and tackled by the General Assembly. But I think that Geneva also is a key actor in this discussion, so I'm very happy to have been able to do that tonight. And I thank you very much for having been with us. And I'd like you to join me in thanking all the panelists, in particular from my right, Dr. Maisato, Gil Gossetti, Ivan Simonovic, Anna-Sophie Greve, and Nigel Rodley. Thank you very much indeed. Let's upload them, and then bear with me just 2 more minutes, because my important task at this stage is to invite you upstairs for the cocktail, to which you are all cordially invited. And besides the drinks, please take some time to take a look at a series of photographs taken by a New Zealand photographer, Henry Hargreaves, whose exhibit is entitled, and it's quite self-evident, The Last Supper. On the basis of the information available, the photographer has taken some images that speak volumes to our emotions and to also to our way of relating ourselves to the end of life. Thank you very much for having been with us, and I hope you have enjoyed it. Thank you.